Great, so it looks like we are ready to begin. So wanted to say thank you again to everybody for joining us. So if you don't mind, go on to the next slide, please. So CCPA enforcement is right around the corner. So today we're going to be sharing a ton of best practices and tips for achieving compliance. So before we get started, we wanted to go over a couple of housekeeping rules. So this webinar is being recorded and it will be shared within 48 hours. This is a live webinar. You can see everybody on their screen shares there. So we will be taking questions. So please feel free to submit them in the Q&A or at the chat, and we will take them at the end of the presentation. If we don't get to your questions today, we will get back to you over email. So before we begin, we also wanted to just go over a quick disclaimer. The opinions discussed in today's presentation are those of the individual and do not represent the firms, company, or entities that they may be affiliated with, nor are they necessarily customers of Active Navigation, Driven, or Maynard, Cooper, and Gale. So with that, I'm going to turn it over to our three great presenters to kick us off. So I'm going to hand it over to you, Dean.
Great, thank you. And it would be a good disclaimer if we didn't say we're also not rendering any substantive legal advice, which for STAR is important. For me, not as much because I'm not practicing, so probably shouldn't take that anyway. I'm Dean Gonzalski. I'm your moderator today. I'm the Chief Revenue Officer at Active Navigation. I am a licensed attorney, but I don't practice any longer. Spent the last 20 years in e-discovery and information governance. And we were actually just talking with Star and Phil on before about Sedona and Working Group 6. So I've got a bunch of experience with those entities in the past. But now I work with Active Navigation. Active Navigation is an enterprise software company that provides file analysis software that allows people to do governance and data privacy compliance work. So that's what we do. And Star, we'll turn it over to you for a quick update on your background.
Hey everyone, I'm Star Drum. I'm a lawyer at Maynard, Cooper, and Gale, a privacy attorney here. I've been practicing since 2009. Started out doing a lot of e-discovery work and transitioned into privacy as compliance and information governance became more important for our clients, and there was a client need for involvement in this area. Like Dean said, I'm on the Sedona Conference Steering Committee for the Working Group on Privacy and Data Security, and I also teach privacy and data security law as an adjunct professor at the University of Alabama Law School.
Great, Sarah. Thanks for joining us. Mr. Favreau, tell us about yourself.
Thanks for having me on today. So my name is Phil Favreau, and my background as well is as a practicing attorney. I've been licensed to practice since 1999 in California, and for the last 9 years as well in Utah. And my background is in civil litigation and resolving business disputes, complex commercial contracts, and so forth, and handling a lot of complex discovery issues during those lawsuits on both sides of the V. I now work as a consultant for Driven on discovery and information governance issues. I advise companies on preservation practices, search methodologies, guidance generally regarding discovery and information related issues, both before and during litigation. I'm also an expert witness on discovery issues and a special master on information and discovery related issues. So that's just a brief overview of my practice background.
Great, thanks. And Phil and I have had the pleasure of working together over multiple years, and we've done a lot of these together. Normally, Phil would be moderating. Phil's a better moderator and attorney than I am. So I'm in dangerous territory here. The good news is we have an amazing amount of content, and we'll just call it CCPA. And if you don't know what CCPA is by this time in the presentation, you're probably in the wrong spot. They do that in airplanes. Like, we're flying to Houston. If you're not going there, you need to get off. So it's going to be all CCPA all the time. I won't read the agenda for you. Let's just get right into it. We will also not attempt to cover all the content in a given slide, and that's why we've kept it pretty robust, and we'll be sending it out afterwards. So let's cover the CCPA pretty quickly. Either of you guys want to sort of do your best, sort of what the CCPA is, and particularly how it's kind of evolved over the last year or two?
Sure. So it, was a quickly drafted piece of legislation that came into being because there was a ballot initiative that had been proposed by our friend Alistair McTaggart, and now there's another ballot initiative that we'll probably get to later, so we'll see if this happens again. But basically, it was a quick and dirty draft of a piece of legislation that's over 10,000 words long, and is very comprehensive in the scope of privacy regulations that it seeks to implement and enforce against businesses in California. And so it's gone through a few legislative revisions before it was passed in its final form. And since then, we've been dealing with the Attorney General, who has developed his own set of regulations that have the same effect of law as the text of the CCPA itself. There are another, they're over 10,000 words long as well. So it's a lot of new law to get in compliance with really quickly. We've been operating with the CCPA in effect since January 1, 2020, and enforcement by the AG starts officially on July 1.
Yeah, thanks, Star. And for folks who haven't read up on it, the sort of origin story of the CCPA is pretty interesting in its own right, and it all happened fast and furious. Well, let's get into some of the particulars. Star, you just hit on a couple of key dates. The 7/1 date obviously is important here. Phil, what's your take on how for a lot of practitioners, do you think there's going to be slippage with the current pandemic and all?
No, the Attorney General seems anxious to begin enforcement, Dean, of this particular law, and has finalized the draft regulations. The regulations themselves may not be approved by the Office of Administrative Law still for several weeks or maybe even months. But the Attorney General's office, whether the regulations are approved or not, is going to begin enforcement on July 1st. I mean, they had even, one of their spokespeople had even indicated, we're going to begin enforcement on or before July 1, which was a surprise to many, since by law they were prohibited from beginning enforcement before July 1, since the regulations still were not completed until recently. So I think they're anxious. I think they also have a limited number of staff persons to be able to help investigate alleged violations of the CCPA. So I'm not sure that they're going to have the ability to go through and ensure that every, how should I say it, violation, no matter how substantive or procedural, is addressed. But I think they will begin taking aim on July 1 and aiming high at those high-profile companies that they believe are not in compliance.
Yep, makes sense. Thank you. Let's get into the scope. It's a pretty broad scope for the CCPA, and obviously California is, a massive state in its own right, and lots of tentacles that, by the way, I'm in California, so one of the folks certainly intended to be covered by this, but kind of walk through kind of a quick and dirty, who does this apply to? And maybe it applies to more people than it doesn't apply to.
Yeah, it's interesting. If you don't mind me jumping in here on this, I think that if you do over 25 million in revenue and you're doing business in California, you're most likely going to be regulated by the CCPA. There is another requirement, and that is that you need to collect consumers' personal information. But considering that you're collecting as a business the personal information of every employee that you have, that requirement is going to be satisfied very easily. So it's really that $25 million threshold, and whether you're doing a business as a for-profit organization. Non-profits would be outside the scope of this.
Yeah, and Phil, I would just add to that, and you mentioned this with respect to having employee data. There is a qualification that's not on this bullet list that comes from the GDPR that has a controller aspect to it that basically says you have to be an organization that determines the purpose and means of the processing in order to be within scope. But once you have employees, you're within scope of that because you're determining the purpose and means. Or if you have a website where you're collecting data for yourself and not solely acting on behalf of another entity. There's no controller processor distinction in the CCPA like we see with the GDPR, but in the underlying text, we see a lot of those distinctions are there.
Right.
Yep. Thanks, Star. And that's what boardrooms used to look like on the far right there, and probably sadly are currently gathering dust.
That looks like you could be socially distant there.
Yeah, two people only. Okay, so I think what was interesting when I first looked at the CCPA, some interesting distinctions, certainly compared to GDPR. Is there anything you guys want to talk about here? There's a bunch now more that sort of come out with in pandemic, right? Geolocation and a few other things. Anything that you guys would highlight as being kind of more novel about CCPA?
Star, what do you think? I mean, to me, it's just so broad. Anything and everything could be considered personal information. And I think some companies really recognize the breadth of this statute and the accompanying regulations. I visited a notable energy provider in California's website today, and they understood this broad definition because right there up front as you visit the website, they had advised the visitor that there was an issue with cookies. We are going to be tracking you, but only with your permission. And you cannot clear that annoying sheet at the bottom, if you will, that annoying page that pops up without addressing that particular issue. Do you want to be tracked? Do you not want to be tracked? And going into the specifics of that. And so I think just even having a sense of that particular issue, that with cookies, that an organization is going to be collecting information about your browsing habits, where you are based, and so forth. And that's a recognition of, I believe, the breadth of the definition of personal information.
Yeah, it is very broad. And especially for the US, this is unprecedented. I think for a lot of organizations that dealt with GDPR and other international regimes that have very broad definitions of personal data, this sort of seemed par for the course. It has a little more specificity than what we see in some regulations, but overall is aligned. A couple of things. There's, the encompassing of a household within the scope of what constitutes personal information. It is broader than GDPR, and that has created some interesting conundrums for businesses who have things like household accounts, things like IP addresses that may be tracked to a household, and putting that within scope. One interesting point on the IP address is that that's in the statute as a category of personal information. The AG had a version of his regulations where he got rid of that, but then took it away because probably it was in the statute and he couldn't have something that was contradictory. And also we have guidance from the FTC and from the European Commission that is a category of personal information. And so he's issued some guidance on, when that's actually within scope of the regulation. But yeah, it's definitely a lot broader than what we generally see in US statutes, especially for data breach statutes, which is where most people are sort of basing their experience from.
Yep. All right. Thank you. Well, let's keep moving. And we've talked to, you just mentioned the household and some of the issues there. Is there anything that, there's a lot, astrological sign, I didn't know that was, I'm an Aries, by the way, in case anyone wants to profile me later. That probably says a lot about it. Anything you want to talk about here that I think is, that you might think is particularly interesting or novel?
I appreciate Star's mentioning of these issues. And I think Star's really covered the constellation on this. If there were any other issues to cover, I just would suggest, again, the extreme breadth of this statute, that the IP address is not just for me, for example, it's for my wife and children. Or if I had decided to invite my in-laws to come and live with me, then ostensibly they could be part of the same household, and using that same IP address, they could be encompassed by this as well. And so if, say, a hypothetical father-in-law in his 80s were searching for geriatric-related products, and my daughter were searching for dresses, and I'm searching for bike racks, all of these could be compiled into a dossier, and information like this about our browsing history could be considered personal information, just to kind of get a sense of how broad it is. Even though it doesn't apply to one person, it applies to a household. And again, household could be considered far broader than what we would traditionally think of it as.
Yep. All right, well, let's start moving into particularly the duties for regulated businesses and obviously the rights for the consumers, which is how the act started. What do you guys want to highlight here? I know there's been a ton around the opt-out right and the right to sort of be forgotten or deleted. What do you guys think is sort of novel and that companies should be aware of here?
I think on the right to know, there's an interesting situation where we've got what the statute says the right to know means, and then the AG and his regulations has taken that and basically bifurcated it into an information access request and a specific pieces of personal information access request. And so procedurally, when you've got individuals who are exercising their right to know, you have to be cautious about which type of right to know requests they're making. They may mean to make all of it, but that is something that was new in the AG regulations that wasn't in the initial statute. And then obviously keeping in mind the timeline for responding to these things. So we've got 45 days. You can ask for an extension for another 45 days. There's a new requirement in the AG regulations that is not in the statute that basically you have to do an acknowledgement within 10 days for right to know and right to delete, to basically let the consumer know we've got your request. So those are things that are important to keep in mind as you're developing your processes for intaking and responding to these.
Yeah, and one of the things we see with customers, utilizing our software is surprisingly how many people struggle with just even understanding their data estate. And so it's fine to say that there's a right to delete and a right for the consumer's right to know, but it presumes that the company understands their data and what they're holding. And that for us is often sort of a primary issue because a lot of these other things, particularly with unstructured data, which is kind of a morass for a lot of companies. So understanding it is the first order, and then being able to remediate it and delete it and audit it is second. Phil, you're about to say something. Did I jump on you?
No, I appreciate you adding that additional clarity on that. I wanted to respond to one point you made about the right to delete as opposed to the right to be forgotten. And the right to be forgotten under the EU is distinct from this deletion right. And if you were to compare the two, just as a rough sketch, imagine you've got some sort of college student that's gone on a drunken rampage and now has a video of himself doing any number of foolish things and seeks to have that video forgotten, let's just say, or removed from Google and other sites. That's quite different from the right to delete, which is to have personal information that a company, a regulated business has, and asking that company to eliminate that personal information from its website, from its stores of information, and so forth. And so there's a key distinction between those two items that's quite fascinating and important to take into account.
Yep.
I'd also say that under the right to delete under the CCPA, there are 16 separate exemptions you could rely on to deny a deletion request. There's like 9 subsections, but within them there are 16 separate exemptions. So if you're actually having to delete information, it's just really going to be a rare circumstance that one of those exemptions is not going to apply.
Okay. Let's talk about some of the key duties here for organizations. What would you want to highlight?
Only that these duties just flow naturally from the rights to consumers. And we're going to go through each of these. So I don't really have a lot to say at this point, other than there are other duties, Dean, that flow from the law and regulations. And this is a webinar that's only 60 minutes. And this statute and the regulations that accompany it, as Star mentioned, are incredibly dense. So they're going to take hours and hours for you to process through if you want to know them. Of course, you could probably just go on to the Maynard Cooper website and just get a good summary from Star and from her firm. But I would suggest that these are just some high-level rights to be aware of. But if you really want to know as an inquiring mind, then get into the statute, plow through it, and get yourself a good cup of coffee or a good Coke because you're going to need it. In fact, a whole pot of coffee to get through that particular statute.
Yeah, and I would say one thing, going back to the last slide, just on the, it says satisfy consumer requests for information, obviously for deletion too. We just talked through that. And then the notify consumers that they can opt out of the sale of their personal information. That's an important thing to note, that is also for businesses who don't sell personal information. That the way the AG guidelines are drafted is that you need to tell California consumers you have a right to opt out of the sale of your personal information. You can follow that up with, but we don't sell it, so we're not giving you that right. But the way the guidelines are drafted, that actually has to be a component of the notice that you provide to your consumers.
Yeah, and interesting, Star, in the notice to consumer of collection, it's this idea that it has to be at or before the point of collection. So going back to this notable energy provider whose website I looked at today, putting the notice about the cookies there is important. That's part of, it's essentially saying that, hey, as soon as you visit one of our web pages, you are at the point of collection. So I think that's a key distinction. If you're going to, say, book a hotel room, maybe they're not using cookies right then and there. Maybe they're only collecting personal information, say, when you begin to enter your name, your credit card number, and so forth. Maybe not. But I think the idea and the recognition of cookies is an important one, because that is, for many websites and many companies, where they are beginning the point of collection.
Yeah, that's right. And, you know, the AG has given some guidance on sort of how he expects the notice at point of collection to be presented. And so there's a few takeaways that, you know, companies could use from that. One good thing about all of the requirements in this is there are cure provisions that are baked into the CCPA. And so to the extent that you're a business that is a little more friendly towards risk or not as conservative as others and sort of want to wait to see what happens, if the AG comes knocking at your door, it's not going to be an immediate fine. So if you want to test something out, us lawyers are really excited for companies to test things out and see how far they can stretch the limits of this regulation. So just know that if you do that, that you've got a little bit of wiggle room to resolve it if it actually turns out to be a problem.
Interesting.
I like the playing with fire approach there. That sounds a little dangerous, but I'm sure folks will do it and see how badly they get burned.
Yeah, and interesting too on this, the requirements for this notice. I'm fascinated by this. It has to be essentially comprehensible to the average consumer. And I've looked at a lot of these particular privacy policies and the notices they contain. And for a law as dense as this, that's filled with as much jargon and legalese, it is next to impossible for a company and its lawyers to prepare notices and policies that are in plain English. They're going to include jargon and they're going to include legalese. It just depends on how much. And it has to be, again, comprehensible to the average consumer and not the average data privacy lawyer or even the average counsel. So that's a high bar, plain, straightforward language and so forth. I think that if you can get it in plain legalese, I'm not going to say the AG's office is going to pass over you, but if you can make it plain and comprehensible using selective colors, bold, italics, bullets, and numbers, you may be able to design a comprehensive policy with notices that is comprehensible to the average consumer.
Yeah, and we'll if we have time, we've got some of those that we can look at later and what are good examples. So I think, Star, you were mentioning the opting out provisions here. Anything you'd like to sort of hone in on or highlight?
Well, like I mentioned, you know, you have to include that in a notice regardless of whether you're actually selling personal information. I will say from experience, even though the opt-out may be one of the easiest parts of compliance in terms of putting this language in your notice, because it's pretty straightforward as far as what you're saying is you have the right to opt out of the sale of your personal information, do so by using this web form. As far as what consumers think that means to opt out of the sale of their personal information, my experience with clients has been that they are not entirely clear a lot of the times, first, that their information is being sold, what that actually means that their information is being sold. A lot of times what they're trying to do really is like an unsubscribe request, like you would have under CAN spam. And so if they continue to receive emails, even though they've opted out of the sale of their personal information, the company that's sending them the emails, we've gotten some angry emails that have come through for certain clients because they're still getting these marketing emails, even though they've opted out of the sale. They're obviously two different concepts. And so just like Phil was saying with putting the privacy policy into an easy to read layman consumer format, the law wasn't drafted that way. And it's a little tough to get the understanding to the masses of what it is this law is actually doing. This is one area where this was not what the GDPR had. There's nothing like this in the GDPR about opting out of the sale of personal information. So there's not really an analogous law that consumers are aware of and can rely on for this type of request. So it's been a new ground for a lot of companies and a lot of consumers.
Yeah, Star, when we say the statute says sale, does it mean literal sale or does it mean monetizing independently for their purposes?
Yeah, it's sale is like trade for valuable or other consideration. It includes monetary sale. It probably includes other types of transfers if you're, exchanging data with a partner where you're doing some sort of a joint marketing venture. Those types of situations probably constitute a sale. Again, that's one of those situations where it's going to be interesting to see who tests what under the statute and whether we get a judicial order on how far a sale actually goes. I know we would welcome something that guides us on exactly what the parameters are, because it's definitely not black and white right now.
Well,
yeah.
I'm going to say we're all going to be a lot older. I mean, probably 100 years from now before there's any comprehensible case law on this. I mean, with the way things work in California, for those who haven't practiced here. So first of all, trial court opinions are completely unavailable or almost nearly unavailable. I guess you could try and unearth them. They certainly can't be cited to. And decisions by the Court of Appeal are frequently unpublished or depublished. And neither of those is considered to be citable authority, and it can be even sanctionable to cite depublished or unpublished cases. So you have a very small number of published Court of Appeal cases, relatively speaking, for a state the size of California, and then you have Supreme Court opinions. And if you contrast that with, say, what's in the federal arena, sure, there are 50 states, but with all the number of districts, but you have your fingertips on any number of opinions from magistrate judges and district judges, as well as the Court of Appeals. So it's a lot easier to get authority on issues in the federal arena than it is in California state. And so I'm not expecting any sort of comprehensible jurisprudence to come out on this for years, something that we can actually weave together and say, sure, there's a clear pattern forming.
Yep, fair enough. All right, let's cover the opt-out button.
Yes, so the opt-out button, if you don't mind me jumping in here, Dean and Star, is an interesting concept. It's not required, at least by statute, but if regulated businesses are going to use an opt-out button, they were supposed to follow the guidance from the AG's office. And the AG, in its first set of regulations published last October, did not publish one. They said, get ready, it'll come. Well, it did come in February, and this is what it looked like. It was this very confusing, the ultimate mixed metaphor of a clear circle saying, come on in, and then a white X with a red background saying, keep out. And it was universally panned by those who were cognoscenti on this particular issue. And so the February regulations, it was published. The March regulations, it was pulled. And in the latest set of regulations that went to the AG's, went to the Office of Administrative Law, the AG said, well, we're working on it still. So there's no guidance yet from the AG's office on what it's supposed to look like. And we all wait for what it may appear to be.
So you can have a button, but it's unclear what it should precisely look like. And you're not advising the red circle square combo thingy.
Yes, and I think if you advance to the next slide, you'll see what we ultimately think of it. That's what it looks like right now. There's nothing there. So
Yeah.
anyway, I think it's a sound concept, the idea of having an opt-out button, because it's this idea about making it comprehensible for the consumer, making it easy for the consumer. Anything we can do to facilitate the issues. And as you had 2 slides ago, you don't need to go back there. The business cannot make it complex or throw up a bunch of roadblocks or put a phone tree to nowhere in order to keep you as the consumer from opting out. So interesting to note that from a consumer's perspective, and also from a business perspective, that you can't throw up these roadblocks.
Yeah, there's a lot here. I was actually talking to somebody the other day, and they asked if I wanted to fax something in, and I thought, well, that's kind of funny, but I guess people still somewhere get faxes. So you have to have 2 methods to submit requests. Anything else you'd kind of point out on here that some of the logistics that would be useful for folks building a program?
The toll-free telephone number has been an interesting conundrum for a lot of clients. It doesn't have to be a dedicated line. It can be an existing toll-free telephone number. I've had one client with a request come through for a toll-free number. I don't know what the original intent was for that to sort of be the primary have-to-have method of submission of a request, but the requests received through some online format, like an email address or a web form, have just vastly exceeded what has happened with toll-free telephone numbers. So, it's a legal requirement if you're not operating exclusively online to have one, but you might want to think about what resources you're putting into manning that line, revising your call scripts, sort of how to manage that process based on the realities of how that function of exercising a consumer rights request is actually used.
Well, and Star, interesting, you mentioned the interactive web form concept, and that can be used under request for delete. But you'll note that it used to be one of the methods for requests for information. It was something that the AG's office had published as part of its October set of regulations, October 19. But earlier this year, the AG's office deleted that part. And you can find that for our audience in the red line version of these regulations. And I was stunned by that that's somehow not permitted for submitting a request for information, because the business wants to make things turnkey. If you set up an interactive web form, it's essentially a no-step process to being able to process the information and then be able to respond. And when you've got it sent into a business by email or phone call or a letter, which is just kind of laughable, or a signed form for a brick and mortar business, I can see that, but still, that's still borderline laughable to see those requests come in. It requires multiple steps and touch points from a business to handle those things, to manually input the data. What you want to do as a business is have it be seamless. So the interactive web form, to me, makes the most sense. And I'm just dismayed that the AG's office eliminated that. I mean, Star, do you read that, like in the second bullet in the accompanying regulations, as eliminating the possibility of using an interactive web form for a consumer to submit a request for information?
I don't actually see that as saying you can't do that, because I think the immediately following bullet says something like, consider the ways in which you interact with our business. And I think it's a may clause instead of a shall clause in the web form. I know from personal experience, we had lots of clients who put up web forms because the statute and the regulation said, this is the mechanism that needs to happen, where you're not solely interacting with your customers online. And so I would be shocked if someone got dinged for having a web form as a mechanism to submit a right to know request. And it's a mandate still for opt-out requests. Like we just discussed, you don't have the button. So by saying companies, you have to have a web form for opt-out requests, you can't use it for right to know requests. That would just lead to absurd results. So I don't think that was the intent or would be strictly enforced. Given the limited resources of the AG's office, I'm not expecting to see them go after a company who's using a web form for a right to know request.
Yeah. And Neve, did we get some questions we wanted to? I saw a couple pop through. Do we have anything that would be topical now?
Yep, absolutely. So we got a great question was, is it okay to have a toll-free voicemail instead of a toll-free telephone number?
That sounds like a legal advice question.
What would non-legal advice, but just
I would say there's nothing in the statute that says you can't have a voicemail.
Right. Right. I agree.
Perfect.
Okay.
Then talking about the sale of information, the next question is using Google Analytics cookies considered a sale?
That's one of those issues that's sort of in that gray area of what is a sale. I will say there's a lot of good resources and language from the AG. If you look at the AG regulations, which are on the AG's website, he's got a supplemental documentation that is basically a response to all of the written requests that came in for comment during the comment periods. And so they've responded to all of them. A lot of them are redundant, but there is some good information about the scope of technical information, what can be gleaned from it. But big picture is that there is a requirement in the regulations that, and in the statute itself, that no company has to undertake the effort of matching disassociated personal information with personal information. So if you've got information that couldn't be considered personal information, and you can't link it with personal information, you don't have to undertake that effort. So to the extent there's a scenario that exists like this with respect to some of these technical issues we've been discussing, the statute does provide that you don't have to undertake the effort of matching non-personal information with personal information.
Well, and start, under the exceptions to personal information, I remember there being a notation about aggregated information, and that is somehow anonymized. And I can't remember the exact provision, but my sense is that Google Analytics may fall into this aggregate information, depending on what aspect of analytics are we talking about. I mean, is it like WebChimp, where you've got access to the precise names of the people who visited? That's different. That's not anonymized at all. But if it's just metrics in terms of raw numbers and figures, then that sort of aggregated information probably is not going to fall under the personal information, or it may fall within the personal information exception.
No, that's exactly right. Yeah, if it's aggregated, that's the exact scenario, right? You can't associate that aggregated information with a specific individual. And so at that point, it doesn't become part of your response obligations to include.
Cool. Thanks, Neve. Let's keep the trains rolling. This sounds like kind of one of the things we were talking about, which is you have to publish your policy, and how do you make it conspicuous and easy to read, not full of legalese and all the other challenges we've talked about. Anything you'd want to highlight here? Pardon the pun with the green highlighter.
I mean, this should be a common sense issue, but nothing when it comes to statutes drafted in California amounts to common sense. I mean, one would think that the statute would have read, here's a privacy policy, and put your notices within the privacy policy. That's intuitive, but they're delineated separately, so there's no specific note suggesting that this is or is not allowed. I'd suggest that it is allowed, since there's no exclusion on it. So you don't have to have a separate notice to consumers and opt out and so forth, separate from your privacy policy. I just want to observe that. And then, Dina, if you recall, as part of our preparation, Star and I were talking about what's conspicuous. How conspicuous does a link to the privacy policy have to be? And from a layperson's perspective, you would think it would stand out more than just any other word within the website. And I think, Star, you had a difference of opinion with me on that. You're not, if I recall our discussion about that correctly.
Yeah, I have no opinions. I just say what the law is and tell people what's your risk profile and how much risk are you willing to accept based on what action you might want to take. But I know that for this particular issue on the conspicuousness, there is prior guidance from CalAPA, which is a an old in terms of privacy law regulation for California websites. It sort of started why we even have privacy policies on websites in the first place. And the AG gave guidelines on CalAPA, used the same term, conspicuous. And actually in those responses to consumer inquiries during the comment period that I mentioned, he actually referred some of the questions to his prior comments on what constitutes conspicuous for purposes of denoting a privacy policy. And it is not the Webster's dictionary definition of the term conspicuous. It's basically saying that the word privacy has to appear in it. There's guidance that it could be all in caps, as long as it's on your homepage, it's conspicuous, as long as the text is a different color from the background text, that's conspicuous. There's really not, again, the textbook dictionary definition of what we think of as conspicuous is not necessarily the requirement. So this is one of the few things where we actually do have some pretty clear guidance on what conspicuous actually means based on prior legislation.
Cool. All right. So let's get into a few real world examples. We can debate conspicuousness and a few other things. So I think some of these animate. Phil, do you want to walk through these? I know this was some of your handiwork, and I'll just keep advancing.
Sure. Well, during COVID-19, we'd all like to be at a property that looks like this, as opposed to being cooped up in a basement like I am right now. So I think we can all reasonably agree on that. And as I go through, and let's suppose I want to make a reservation at this wonderful property with an ocean view, I'll take the king on that one. Now, when I go to input my personal information, and if you go back one, it's nice to see that there is a statement about see our global privacy statement. And that looks, it may not be in the home page, Star, but that's pretty conspicuous at the point of collection. I don't know about cookies on this website. I can't speak to that. But when they're going to collect, when this particular provider is going to collect my personal information, including my name, my email address, my credit card information, that's a big deal. They are putting me onto their privacy policy. So I like that.
Yeah, this is a good point of collection. And just to be clear, the homepage thing is not it is one of, there's a bunch of potential ways to satisfy conspicuous. So homepage is one of them, but it is not the only way. But for the purposes of the CCPA point of collection, I agree that this is a great presenting, great way to present it right there. And this is actually conspicuous dictionary definition of conspicuous, I would think.
All right, you guys agree. This is no fun. We'll have to argue here shortly on something.
No problem.
All right. All right, so you're going to go in here. Oh, sorry, one more back. Okay, now we go.
And so, you know, with this, we don't have anything about California, which, you know, some might say, well, wait a minute. Where's my California-related information here? I'm ready to submit my request for information, and I want to see more details on the privacy policy. And again, there is a link to the bottom on See Complete Privacy Center. So you do have to do some navigating. It's not just right in front of you, but then I didn't ever see a requirement in the CCPA that provided that everything had to be right in front of you without any navigation. So I think this, to me, we're not passing judgment on this. I just think it provides, some of these policies we're looking at provide a nice benchmark for whether we think this is something that's useful for consumers in this, for this particular business and for others. Again, I'd point to and suggest, take a look at some of the notable energy and providers in California and look at their websites. They know their targets beginning July 1, right? They're very high profile. And I think that the one I looked at does a great job of laying these issues out. Anyway, we can keep going if you want, unless Star has a comment here.
Well, I'm waiting for Star to disagree with you.
I mean, these are, I will just say in practice, this is the toughest thing. Phil, you mentioned earlier about, you know, it has to be plain, easy to read. You know, the GDPR has a requirement that privacy notices be short while, you know, specifying dozens of different pieces of information that they have to include. So sort of putting together the entire privacy policy and checking off the list of everything that needs to be in there from all these statutes is the easy part. Condensing them into these sort of overview, shortened versions or simplistic layman's, front facing before you get to the full scope of it. That's really the difficult part.
That's the trick.
All right, let's, we've got one other version. Let's,
Yeah, so you can see on the right side of the screen, California Consumer Privacy Statement. When we go to the Privacy Center, that's the money link, okay? We're finally getting closer, and you can see it was last updated May 4th. So let's click on the California Consumer Privacy Statement and see what it shows us, okay? Well, personal information we collect. One thing I like about this is that they delineate what they collect, and it's not bunched together in very tiny font. It's not huge font either, but I like the bold font, personal information we collect. I like they've spaced it out with paragraphs and so forth, and lettered it to help not just a reasonable lawyer, but a reasonable person, an average consumer, be able to tick through these if they want.
Yeah, and this is a pretty common approach for companies that know what they're doing with respect to making these disclosures and breaking it out, because these categories, if you go and look at the CCPA statute and the definition of personal information, they directly align with the subsections of that part of the statute. So it's a defensible legally way to present it. It also does make it easier for consumers to break it out like this. So I like this type of presentation. I like charts. I like things where, yeah, it's simple and bulleted. It's funny, there's a category listed out in the categories of personal information under the statute that is thermal information, which I used to laugh about, like, haha, who's collecting thermal information? And now that all of our temperatures are taken pretty much everywhere we go, that has been added to a lot of privacy policies. Yeah,
is that thermal information that is defined as your temperature would be a?
So it's defined as like thermal, olfactory, and other sensory information. So that's how the statute defines that category of information. So it's sort of it's a sensory catch-all. And so within these categories, some companies take all of the different identifiers listed out within a category, and some just list the specific identifiers within a category. So some are saying thermal information, some are not putting it because some see the temperature gun collection as, because it deletes the data, it's not associated with a specific individual, as not falling within the scope of needing a disclosure. That is not a conservative approach, I'll say that. I don't know why it would hurt to include a category if you're collecting it at some point, but it's definitely been something that we've been adding to privacy policies.
Well, just one little interesting note on this. I know we're starting to get short of time, but I did read yesterday that in South Korea, they have just recently found out that the government has held on to personal information from its citizens relating to the last outbreak of a respiratory disease in South Korea. And there are concerns about the government there holding that information way too long, since I think 2015 is when that last outbreak wrapped up. At least that's what I read. And it highlights the issue that these policies and procedures apply only to for-business or for-profit businesses. They don't apply to the DMV, which likes to sell our information, as I understand it. And anybody who's lived in California knows it's the most unfriendly place on the planet. So just be aware that these provisions don't apply to state actors. And during COVID-19, state actors are some of the, there's a potential for abuse of personal information and the retention of it. So I just wanted to spotlight that particular issue.
Yeah, public entities are subject to the Privacy Act of 1974, so it's very current and very relevant to the times we're living in. There's been some more since then, but yeah, it's definitely a different world in terms of surveillance that the government can have.
Sorry, Star, just a quick question on some of the E through H in the limited circumstances, they say we may do a bunch of these other things. As a consumer, where does that kind of, seems like that would leave the consumer in kind of a tough spot to not know whether they're actually collecting those or not. And those are some pretty broad lists. So do you like that, without legal advice, do you like that kind of, we may also do these other things clause?
So it's not ideal. It's sort of tough when you get into your broad privacy statement where you're told you have to incorporate everything. These are categories where when you have a point of collection notice, you should be told that. So if you start being geolocated by this company, presumably by an app, there would be a notification on the app that says you're being geolocated, or even better, you have to opt in order for that to happen. So I think that, you know, again, these are sort of, it's really easy to put in all this stuff when it gets to these sort of nuanced situations where we do this sometimes, but not all the time. We can explain every circumstance in which we do all of these things, but then our privacy statement is going to be 100 pages long. Then are we violating the simplicity requirements? Navigating those issues is definitely not that easy.
Yeah. Okay. Thank you. I think we've got one or two more on this one. Phil, anything you kind of wanted to point out from this particular policy?
No, let's just keep going. I think you can see at the bottom there's some other things that could be clicked on, but let's keep going, I think, at this point.
Okay. And I also want to be wary of sort of the interest of time and make sure we get to resources and questions. Do you want to hit this one really quickly?
I think just one thing to be aware if we advance this one slide or one animation, privacy down there, it's in white font with the green background. It doesn't really.
It's right under alcohol delivery. We're all
yeah, yeah, exactly. That's the COVID-19 choice of self-medication, as I understand it, for many people. But it doesn't really stand out any more than alcohol delivery or press. And is that conspicuous or not? I don't know. We'll have to figure it out from the AG's office. My preference would probably be to put it in a different font. You could leave it the same font size, but maybe a different font color. But I think what's noteworthy, if you will, go one more animation if you could, is that this is Roman numeral 1 in this privacy policy. And to get to the CCPA issues, you need to scroll down to Roman numeral 8. And it's not like it's just a page. It takes a long time to get there. And that doesn't mean that it's violative of the law. It does mean that maybe you could put some sort of table of contents with hyperlinks up there, guiding your readers and your visitors so they can get a clearer sense of where those disclosures might be. So that would be one thing I'd like to add, but that I like all of the underline and bold language there on the disclosures and calling out that for particular consumers who may want to get more detail on what is actually being collected.
Yeah, and while we're just so we can make sure we're going to end on time, let me scroll forward, and I want to make sure if we can have maybe some tips for compliance and then resources. Folks will get this deck. Anything you or Phil, you or Star would want to call out here as key tips for folks beyond the full list?
I think, and this may have been on a different slide, but sort of before you get to number 1, you definitely need to know what data you have, where it lives, where it comes from, and where it's going. So, if you haven't done that yet and we're a week away from enforcement, you've got a lot to do in a short period of time. And it's an ongoing process, right? Your data is always changing hands, but doing data maps and data inventories to know what personal information you have is really important, not just for CCPA compliance, but for litigation risk, for cyber incident risk, and reducing your risk of exposure in the event of a breach. So that would be a before number 1 step I would recommend.
Yeah, good point. Phil, anything on here you'd highlight?
Oh, and it's in number 2. So just kidding, it's there as part of the.
It wasn't conspicuous enough. We needed to highlight it.
This is a pretty good summary, Dean. I mean, there's any number of other steps an organization could take, but this is a pretty good summary of best practices and tips.
And maybe on the last one, just to underline that for a second, for folks who went through GDPR, you can't just carbon copy this one over. They're different enough that they need their own separate body of work. Is that fair?
That's very fair. I mean, like we said, there's no opt-out in GDPR, so that creates a whole new universe, especially if you are selling personal information of requirements. And there's also, we didn't really discuss it today, but there's this distinction between businesses and service providers that's similar to controller processors, but the language you have in place with someone who is a service provider is different than what you would have a GDPR controller processor agreement. So where you've got vendors who are processing your data and you don't want that transaction to be viewed as a sale, because as we talked about, that's a really broad definition. You need to look at those agreements and make sure you've got the right language in place. So there's just another item to add to the list, is make sure you got your service providers within scope of the CCPA.
Okay, thanks, Star. Well, let's make sure we get to resources here. We've got a few resources for folks to take a look at. Phil is a prolific writer. I'm only at the tip of the iceberg with Phil talking about this. And Neve, do you have a minute or two to see if we could get any questions in?
Yep, I think we have a couple of minutes and we've got a ton of great questions come in. So the first one is, do we have any idea of which states might pass similar legislation?
Well, Washington State has been trying to pass legislation the past couple of years. And one of the proposals was was similar to the CCPA. And then another proposal was CCPA on steroids, but none of these proposals got through. I think COVID-19 and other issues derailed it, but those issues will be brought back up, no doubt, next year during Washington's legislative session. So I would say stay tuned for what's going on in the state of Washington.
Yeah, Washington, New York has been, sort of bubbling up with similar things. At the federal level is really what the highest amount of interest is in, because if we get a patchwork of state regulations like this, the compliance requirements for this are going to become crazy. Nevada actually enacted something like the do not sell prior to California. And so you've already got websites that have a do not sell Nevada, do not sell California. Just imagine that 50 times over. Still have the compliance requirement to be succinct and easy to understand. It's going to be crazy. So we'll have to see what happens. But COVID's definitely slowed down a lot of the legislative activity this year. There's also in California a new ballot initiative, the CPRA. So that's Alistair McTaggart, who started the CCPA. Has basically, because now this was passed by the legislature, he thought it took out a lot of the consumer friendliness of his original intended ballot initiative. So he has gone back to the well, and as of a court order yesterday, it looks like, assuming the signatures get verified by all of the counties in California, that the CPRA will be on the ballot this November, and that creates a whole new host of enforcement requirements and creates a new enforcement body within California to oversee that regulation. And they're just a privacy and data security enforcement body. So that'll be interesting.
So that comes if your taxes in California aren't high enough, just enjoy paying for that new regulatory body. And it's debatable whether it's going to get on the November ballot. There is some controversy over that, and I'll be interested to see if it's on the November ballot or if it's going to have to wait until 2021 or beyond to be voted on.
Well, that sounds like a good cliffhanger to leave the audience on, and sounds like a good volume too for another webinar. So Neve, if it's fair, I'll wrap us up unless you have any other housekeeping items.
Nope, that's it.
All right, so thank the audience for joining us today, and Star and Phil, thanks so much for helping present, and everyone else have a great day.
Thanks for having us, Dean.
Thanks. Cheers. Bye-bye.